Well, y'all favorite little homie just got sent up the river, or better yet, they kept up his murder conviction because Lil Rod, it's over. Bali, it's over. We'll read the whole entire 28-page finding and denying. So there you go. If you don't want all that, I'll tell you exactly what just happened. Let's go. Sorry to say this. Blaylock versus State, Ryan versus State, Bethel Justice, appellants Des Moines Blaylock and Redalius Eugene Ryan Jr. were convicted for the malice murder of Jamari Holmes, the aggravated assaults of two other individuals, and other related crimes on appeal. Both appellants contend that the trial counsel rendered ineffective assistance in several ways. We also review whether counsel's alleged deficiencies, when viewed cumulatively, require reversal of his convictions. For the reasons that follow, we affirm. 1. Viewed in the light most favorable to the jury's verdicts, the evidence presented at trial showed the following. On the day of the crimes, appellants Tahira Hartford and Mariah Smith were at Blaylock's apartment. Hartfeld invited Bernard Mitchell, Rodney Uten, and Jamari Holmes, the victims, to meet up with her and Smith. Where the victims arrived, Hartfield and Smith got into the victim's car, and Hartfield directed them to a nearby apartment complex where Ryan resided to buy marijuana. Upon arrival, Mitchell parked his vehicle, and the victims gave money to Hartfield, who exited the vehicle to purchase the marijuana. Hartfield returned a few minutes later and told Smith to come with her because somebody needed to see her. Smith got out of the car, and when she reached the apartment stairs, heard gunshots and saw appellants shooting at the victim's car. Neither Mitchell nor Uten saw the perpetrators clearly enough to identify them, but both told the police they saw a shooter who was tall with dreadlocks come out of the apartment breezeway with an assault rifle shooting at the car. Mitchell also told the police he saw another shooter at the corner of the building, though Mitchell did not recall seeing a second shooter at trial. Mitchell and Uten fled on foot after Mitchell's vehicle malfunctioned. Smith and Hartfield hid nearby until Ryan picked them up, and they returned to Blaylock's apartment. When officers arrived at the crime scene, they found Holmes, who had been shot in the back of the head in the passenger seat of the victim's car, which had several bullet holes in the exterior. Holmes was taken to the hospital and died shortly thereafter. Investigators determined that the fatal bullet entered through the rear of the car, pierced the back seat, and exited through the front passenger seat where Holmes was sitting. A 7.62 millimeter bullet fragment was recovered from Holmes' head during the autopsy. At the crime scene, officers recovered 7.62 millimeter shell casings and 9 millimeter shell casings. Ballistic tests showed that the 7.62 millimeter casings were fired from the same gun, most likely a rifle, and all the 9 millimeter cases were fired from the same gun, most likely a pistol. Investigators determined that the 9 millimeter rounds were likely fired from the corner of the building close to the victim's vehicle, consistent with Mitchell's initial account of where the second shooter appeared. After fleeing, Mitchell and Uten called Hartfield and asked, "Why they shoot at us?" Hartfield replied, "They said that y'all was parked in front of the spot." Hartfield then texted Mitchell claiming, "We did not set you up." Mitchell and Uden reported Smith's and Hartfield's potential involvement to the police, and shortly thereafter, officers located and interviewed the two women. The interviews were video recorded and were admitted into evidence at trial. Although Smith initially refused to admit that she saw appellants shooting at the victims and instead provided several alternative accounts of the crimes, she ultimately admitted to seeing appellants shoot at the victims. In contrast, the lead investigator testified that Hartfield was not cooperative during her interview and did not provide any information about what happened at the incident. After her interview with the police, Hartfield messaged appellants on Instagram that she stayed silent and told police that she did not know what happened, but that Smith was snitching, so the police know about Blaylock, but not Ryan. Blaylock replied that he knew that Smith was a rat and asked what Smith said about him at trial. Mitchell, Uten, Smith, and Hartfield testified for the state. Smith's explanation of the events at trial aligned with the victim's testimony of what took place at the crime scene. And that is that the victims picked up Hartfield and Smith from Blaylock's apartment. Hartfield directed the victims to the scene of the crime. Hartfield exited the vehicle before returning to retrieve Smith, and then shots were fired from the victim's vehicle. Smith also specifically testified that she saw appellants fire their weapons at the victims and explained that she initially lied during her interview with the police because she feared retribution by appellants. During Hartfield's testimony, she invoked her right against compelled self-incrimination numerous times because although not charged in connection with this crime, she was under indictment for the other charges at the time of the trial. However, Hartfield also provided some substantive answers, such as denying that she knew Ryan, denying setting the victims up, and denying direct appellants to shoot the victims. Appellant's theory of defense was that neither appellant was present during the crimes. Throughout the trial, appellants implied that Hartfield and Smith were shooting the real perpetrators. Blaylock argued in his opening that the reason appellants were on trial was because Hartfield and Smith don't want to tell what really happened. To that end, appellants sought to persuade the jury that the state failed to present sufficient evidence to prove appellant's guilt beyond a reasonable doubt by highlighting Smith's shifting accounts of the crimes of Hartfield's invocation of her right against self-incrimination. For example, during closing, Ryan explained that the problem with Hartfield's invocation of her right against self-incrimination was that her silence didn't really help the jury figure out what happened. Both appellants contend that trial counsel rendered constitutionally ineffective assistance by failing to object to move to strike Hartfield's testimony after she invoked her right against self-incrimination in the jury's presence, and failing to object to the trial court's charge on how the jury should assess Hartfield's invocation of the right, failing to review and introduce certain evidence that would support appellant's defense, and not objecting to each of the prosecutor's comments on the appellant's silence during closing argument. Ryan separately argues that trial counsel was ineffective for failing to investigate his alibi. We address these arguments in turn to prevail on a claim of ineffective assistance. Appellant bear the burden of showing both that trial counsel's performance was professionally deficient and that they were prejudiced as a result of that performance. See Strickland versus Washington. This burden, though not impossible to carry, is a heavy one. To show decent performance, appellants must demonstrate that counsel performed at trial in an objectively unreasonable way, considering all the circumstances in the light of the prevailing professional norms. Our inquiry focuses on the objective reasonableness of counsel's performance, which we evaluate in conjunction with the attendant circumstances and though the lens of counsel perspective at the time, while also making every effort to eliminate the distorting effects of hindsight. Thus, deficiency cannot be demonstrated by merely arguing that there is another or even a better way for counsel to have performed, nor does counsel's subjective state of mind have any bearing on our analysis. The fact that defense counsel failed to articulate any strategic reasons for his failure made no difference because our inquiry is focused on the objective reasonableness of counsel's performance, not counsel's subjective state of mind. If a reasonable lawyer might have done what the actual lawyer did, whether for the same reasons given by the actual lawyer or different reasons entirely, the actual lawyer cannot be said to have performed in an objectively unreasonable way. To show prejudice, appellants must establish a reasonable probability that in the absence of counsel's deficient performance, the result of trial would have been different. It is not enough to show that the errors had some conceivable effect on the outcome of the proceeding. And if an appellant is unable to satisfy one prong of the Strickland test, this court is not required to examine the other prong. See Brady versus State. In their first claim of ineffective assistance, appellants challenged trial counsel's performance with respect to counsel's handling of the following series of events. Before Hartfield testified at trial, her attorney indicated that Hartfield would invoke her right against self-incrimination pursuant to the Fifth Amendment of the federal Constitution outside the jury's presence. The trial court discussed at length Hartfield's anticipated testimony with the parties and Hartfield's attorney, as well as the types of questions which Hartfield could potentially respond without incriminating herself. The trial court emphasized several times, and the parties agreed, that Hartfield cannot refuse to respond to questions that would not elicit incriminating responses. The state ultimately called Hartfield to testify on both direct and cross-examination. Hartfield invoked her right against self-incrimination numerous times, though she also provided substantive responses to some questions. Appellants raised no objection during Hartfield's testimony to her invoking her right against self-incrimination. During closing arguments, counsel relied on Hartfield's silence to argue that the state failed to present sufficient evidence to prove appellant's guilt beyond a reasonable doubt. During deliberations, the jury submitted the following question to the trial: how shall we interpret pleading the fifth? After both the state and defense counsel assisted in crafting a response, the court instructed the jury as follows. The Fifth Amendment to the United States Constitution guarantees that an individual cannot be compelled by the government to provide incriminating information about herself. The so-called right to remain silent. When an individual takes the fifth, she invokes that right and refuses to answer questions or provide information that might incriminate her about this case or any other. How this concept factors into your fact-finding and ultimate decision is for you to decide. Appellants did not object to this instruction. Appellants now argue that the trial counsel performed deficiently by failing to object to move to strike Hartfield's testimony after she invoked her right against self-incrimination in the jury's presence, and failing to object to the trial court's response to the jury's question. In support of these claims, appellants highlight the testimony of both their trial counsel at the motion for the new trial hearing, specifically testimony that counsel had no strategic reason for not objecting to either Hartfield's invocation of the right against self-incrimination in the jury's presence or the trial court's response to the jury's question. We are not persuaded. We turn first to appellant's argument that the trial counsel were deficient by failing to object and move to strike Hartfield's testimony after she invoked her right against self-incrimination in the jury's presence, pointing to decisions of this court and others that have recognized the potential for fair prejudice that may arise from a witness's assertion of her right against self-incrimination and the adverse inferences that may follow. Appellants contend that their rights to due process to control the witness against them were violated by Hartfield's assertions of that right here. Neither side has a right to benefit from any inferences the jury may draw simply from the witness' assertion of the privilege, either alone or in conjunction with questions that have been put to him. Citation and punctuation omitted. So they say trial counsel were deficient for failing to object to move to strike Hartfield's response on that basis. But even assuming that an objection in motion to strike Hartfield's testimony would have succeeded, we conclude that it was not objectively unreasonable strategy was not an objectively unreasonable strategy to forego objecting and moving to strike Hartfield's testimony, since the strategic decision is one of several reasonable counsel could have made. The record shows that rather than objecting and moving to strike Hartfield's testimony, trial counsel opted to use Hartfield's testimony or lack thereof to bolster appellant's theory of defense. Specifically, during closing arguments, trial counsel emphasized Hartfield's refusal to respond to questions about her role in the crimes as part of their defense, that the state failed to present sufficient evidence to prove appellant's guilt beyond a reasonable doubt. Ryan pointed out that Hartfield declined to answer almost everything she was asked and explained that if the problem with Hartfield's invocations was that her silence did not really help the jury figure out what happened, both appellants referred to Hartfield's silence in an effort to cast doubt on the evidentiary value of the inculpatory Instagram messages sent by Hartfield to appellants that were introduced during trial. Namely, Hartfield's message to appellants that she stayed silent after her interview with police by telling the officers that she did not know what happened, but that Smith was snitching so the police know about Blaylock but not Ryan. Ryan urged the jury that Hartfield's refusal to respond to questions about the Instagram messages were critical because the case is about what is proved, not about something that is suspicious, not about what might have been. It's about evidence. Ryan also suggested different reasons why Hartfield sent the message that did not implicate either appellant as a shooter, concluding that without the context of that message, the state had not proved its case. Blaylock likewise emphasized the dearth of evidence presented by the state, arguing that the state's case hinged on Smith's shifting accounts of the crimes and the inculpatory Instagram messages, an argument that was only strengthened by Hartfield's refusal to provide any substantive response regarding the crimes, choosing to address Hartfield's attorney this way in closing arguments rather than objecting and moving to strike Hartfield's testimony was an objectively reasonable strategy and provides no basis for deficiency. It is a sound defense strategy to minimize objections to a witness testimony in an effort to show the jury that the defense has nothing to hide, and to instead use the witness's testimony to counsel's advantage during closing argument. The making of objection falls within the realm of trial tactics and strategy, and thus usually provides no basis for reversal of a conviction. Citation and punctuation omitted. Moreover, a reasonable attorney also could have decided not to object and move to strike Hartfield's testimony to avoid drawing the jury's attention to the questions in Hartfield's invocation of her right against self-incrimination in response. See Rashad versus State. It would not be objectively unreasonable for trial counsel as a matter of trial strategy to refrain from objecting to this testimony so as not to draw attention to it. Finally, trial counsel were not deficient for failing to object and move to strike Hartfield's testimony because Hartfield gave several substantive answers that supported, at least by implication, appellant's defense. Hartfield denied knowing Ryan and denied setting up the victims or directing appellants to shoot the victims. Each of these denials could help cast doubt on appellant's guilt. As such, it was not an objectively unreasonable strategy to forego objecting and moving to strike Hartfield's testimony. That the jury apparently reach different conclusions about Hartfield's testimony does not mean that no reasonable attorney could have chose this approach. Could have chosen this approach. The law is well settled that the decisions relating to trial strategy and tactics are not to be judged by hindsight. We now turn to appellant's argument that trial counsel were deficient by failing to object to the trial court's response to the jury's question because they assert it improperly authorizes the jury to draw inferences from Hartfield's invocation of her right against self-incrimination that were adverse to appellants, but as we have already discussed, the record reflects that during closing arguments, trial counsel sought to capitalize on Hartfield's invocation of her right against self-incrimination as part of their theory or defense, repeatedly pointing to Hartfield's silence as demonstrative of the state's failure to produce sufficient evidence to prove appellant's guilt. In light of that closing argument, it was not an objectively unreasonable strategy to forego objecting to a jury instruction that permitted the jury to factor Hartfield's silence into its deliberations in hopes that the jury would view the lack of testimony from a key witness as to what happened on the night of the crimes as an indication that the state had not presented sufficient evidence to prove its case. Thus, under the circumstances of this case, we cannot say that the trial counsel's decision to forego objecting to a jury instruction that could have benefited the defense was objectively unreasonable. The trial counsel's decision not deficient where failure to object to trial court's comments could be helpful to appellant's case. Trial counsel not deficient where failure to object introduction of certain evidence may have helped defense. Counsel's decision to not object to prosecutor's comments that may have helped support their defense, not objectively unreasonable. For all these reasons, we conclude that the appellants have failed to establish that trial counsel's performance was deficient, and this claim of ineffective assistance fails. In the next claim of ineffective assistance, appellants argue that trial counsel performed deficiently by failing to review and introduce into evidence Instagram messages provided by the state during discovery that, according to appellants, would have cast doubt on the state's theory of defense specifically. Appellants point to Instagram messages sent by an unidentified user who asked Mitchell how he let Holmes get killed, to which Mitchell responded, "We didn't let him get killed. Hartfield and Smith set us up. We shot back." Mitchell reiterated in another message, "We were shooting back." When asked about these messages at the motion for new trial hearing, Blaylock's counsel did not recall seeing the messages during her review of the records, and Ryan's counsel testified that he was not aware of the messages before trial. Appellants argue that these messages undermine the state's ballistics evidence and testimony from investigators that two shooters fired from outside the vehicle and that none of the victims returned fire, as well as Mitchell's testimony that although he had a gun, it was unloaded. He did not fire at anyone, and he did not see anybody else fire from within the victim's vehicle. The trial court found that trial counsel were deficient in failing to find the Instagram messages, and state does not dispute that finding. However, the trial court also found that appellants had failed to establish Strickland prejudice as a result of deficiency. We agree. Although Mitchell's messages about shooting back may cast doubt on some of the state's evidence, we cannot say that introducing the evidence would have created a reasonable probability of a different outcome. Here, an acquittal, Lee versus State, first given that Mitchell claimed to have fired back. The text messages, in fact, bolster evidence that shots were fired from outside the vehicle first. Second, the messages do nothing to undermine the strong evidence that the fatal shot came from outside the car. Investigators determined that the fatal shot entered the rear of the car, pierced the back seat, and exited through the front passenger seat where Holmes was sitting. Further, evidence showed that the fatal 7.62 millimeter bullet could not have been fired by a .22 caliber gun, which was the caliber weapon that Mitchell admitted was on his person at the time of the shooting. Third, even if Mitchell's messages were presented to the jury and we assume the jury would have credited them, the messages do not definitively prove that there had only been one person shooting at the victims, as appellants claim. Appellants appear to reason that the ballistic evidence presented at trial showed there were only two guns used at the crime scene. Therefore, Mitchell's message would show that there were at least one victim shooting from the car, counting from one of the guns, leaving only one shooter outside the vehicle, firing the other gun at the victims. However, the state's ballistics expert testified that at least two different guns were fired, but explicitly clarified that he could not testify that only two guns were fired. Accordingly, appellant's argument that Mitchell's messages would have conclusively dispelled the state's theory is inaccurate. Given these circumstances, appellants have failed to establish a reasonable probability that the result of the trial would have been different had trial counsel reviewed and introduced into evidence the Instagram messages, and thus have not shown the requisite prejudice to support their claim of ineffective assistance. No prejudice from counsel's failure to review a witness's prior contradictory statement because, among other reasons, such evidence was not exculpatory. No prejudice where even if counsel had not failed to carefully review the case files, the outcome of the trial would not have changed based on other evidence. Appellants also argue that trial counsel were ineffective for not objecting to the prosecutor's comments during closing arguments, which contend impermissibly commented on the invocation of their right to remain silent. Again, we disagree. During closing arguments, the prosecutor acknowledged that the defendants carried no burden, but urged the jury to listen for appellant's explanation in response to the following question. If defendants were not committing the murders, where were they? Appellants objected to the comment as burden shifting, but the trial court overruled the objection. That's actually that actually is burden shifting. What the hell? That's crazy. You can't say that. Anyways, the prosecutor repeated the question, emphasizing that the defendants are both saying they weren't there. Tell us where you were. We didn't hear any evidence of it, obviously, but I would also still like to hear that answer. Blaylock again objected to these statements as burden shifting. The trial court sustained the objection and instructed the jury, tell us where they were should be disregarded. All right, cool, because that's 100% burden shifting. Um, in his rebuttal closing, the prosecutor returned to the same thing. I wanted to hear the answer to the question. If they weren't committing the murders, where were they? The prosecutor continued to ask, at any point did you hear an answer to the question? I did not, because they can't. They can't answer the question because the answer is they were committing the murder. The prosecutor continued, the defense does not have to call a single witness to present a single piece of evidence in the case, but they can if they have it. But they didn't because they don't have it. The trial counsel did not object to these comments, permitting, sorry, permitting whether trial counsel were deficient by failing to object to each of the prosecutor's purportedly improper comments. Appellants have failed to establish the requisite prejudice in light of the strong evidence of their guilt, including Smith's testimony identifying them as shooters, the victim's testimony that corroborated Smith's account of the crimes, and the inculpatory messages sent between appellants in Hartsfield, C. Davis versus Georgia. No prejudice from counsel's failure to object to comments during the state's closing argument, where the state presented substantial evidence of the appellant's guilt. Stroller versus State. No prejudice, even assuming counsel was deficient by failing to object during closing argument. Other evidence of the appellant's guilt was very strong. In addition, the prosecutor's statements were not evidence, and the trial court purportedly instructed the jury as such. This claim of ineffective assistance therefore fails. Ryan argues separately that trial counsel was deficient by failing to investigate and present his alibi to the jury. Specifically, Ryan argues counsel should have called his half-brother, who would have testified that he and Ryan were home playing video games at the time of the shooting. We disagree that trial counsel performed deficiently in this request. Counsel has a duty to make reasonable investigations or to make a reasonable decision that makes particular investigations unnecessary. In any ineffective case, a particular decision not to investigate must be directly assessed for reasonableness in all circumstances, applying a heavy measure of deference to counsel's judgment. Terry versus Jenkins. Moreover, a decision as to which defense witnesses to call is a matter of counsel's trial strategy and tactics will not support a claim of ineffective assistance of counsel unless it is so unreasonable that no competent attorney would have made the decision under the circumstances. Smith versus State. Here, trial counsel testified at the motion for new trial hearing that he was aware of a potential alibi defense, but elected not to pursue it any further after he conducted a mock examination of Ryan, which did not go well. Counsel testified that he did not believe an alibi defense would be persuasive unless Ryan testified, and also noted that evidence at trial contradicted a purported alibi. Counsel instead thought it would be better to argue that there was only one shooter and the other shots came back from the alleged victims. As a result, counsel elected not to investigate the alibi defense any further. Given the conflicting evidence and counsel's objectively reasonable concern about the strength of an alibi, we cannot say that counsel's strategic decision not to investigate and present Ryan's alibi defense was unreasonable. See Smith claimed that counsel was ineffective for failing to investigate and present alibi defense failed where a witness placed defendant at the crime scene, and counsel believed that an alibi presented by defendant's girlfriend would not be persuasive. According, this claim fails. Finally, we consider whether the combined prejudicial effect of trial counsel's assumed deficiencies warrant a new trial. See Schofield overruled on the grounds State versus Lane. In our review of appellant's claims, we assume that counsel were deficient for failing to review and introduce into evidence Mitchell's 2 Instagram messages and failed to object to each of the prosecutor's comments on silence and closing argument as discussed in Divisions 2B and C. Counsel's assumed failures are unlikely to have affected the outcome of the trial, and we do not see that the prejudice from these 2 deficiencies will culminate in any way to cast doubt on the verdict. C. Lee, 318 Georgia. Given the relatively minor impact of counsel's assumed errors, the appellant has not shown that the cumulative prejudice from those assumed errors likely affected the outcome of his trial. This claims therefore fails. Judgments affirmed. All justices concur.
So what the court said is this: you can't have your cake and eat it too. Y'all said because she pled the fifth, that wasn't enough evidence to convict, but y'all said now that because she pled the fifth, we should have struck her whole entire testimony. Which one is it? And then it served the defense to bring that up in the favor of, and it seemed as though from outside observations from the courts that, hey, bruh, you actually got a lot of favorable things done for you. When they burden shifted, boom, they struck that. If you don't know what burden shifting is, it's when the prosecution basically says that the defense will show zero evidence to prove that they didn't do the allegations that we brought up against them, which begs the question of, if you're bringing up the charges against me, why do I have to prove I'm innocent? Why can't you prove I'm guilty? That's how the criminal justice system is supposed to work in the eyes of the laws. So with that being said, I hate to say it this way, but yeah, he was going to be found guilty. The hell? Y'all went, seen some cats, didn't know who they was, young dudes, shot, took the life of one, and that's how they go. I got to ask anybody who's on Lil Rod's quote-unquote side, don't be. Don't be. Be sad of the environment that he participated in, 100%. Be sad of the decisions that he made, sure, but be sad for the victim as well. People got to remember, there are victims to crimes, and it seems as though for some of the victims in these crimes that happen, that there's such a propensity for the defense that we forget they're still victims. Lil Rod was never coming home, bruh. Lil Rod was only on the YSL stuff because of him saying free bris and doing a bunch of illegal stuff behind bars, and him wanting to be YSL so bad. He never even met Young Thug until he came to that trial. So there's that part. Then added with the fact he was only put there really to diminish everybody there so they can have a convicted murderer even though he was going up on appeal. And you don't think that that appeal was set up so that they could keep out the conviction of the murder? Or that they could say, hey, yeah, that trial that he had, which, and this is what they 100% did, the trial he had was terrible, ineffective counsel, this, and that. And that's when you seen his lawyer and then the other lawyer go through and destroy Santa Claus. I would put that video up on here, but it's already a long ass 30-minute video any doggone ways. So there's that. But yeah, bro, they weren't going to be found not guilty. If anything, they were going to show how guilty he was. And when you do that, it just is what it is. So, unfortunately, bro, young cats make mistakes. I'm guaranteeing that stuff took no longer than 30 seconds for them to do all that stuff. 30 seconds of their life cost them their whole entire life, and they're not coming back. But to the victims, man, prayers. To the families of Lil Rod, prayers. But ultimately, man, he wasn't getting out of prison. So it is what it is. Unfortunately, he's going to be another statistic, another walking example of what not to do, and another example of a failed society with failed principles and failed people inside of it that paints the illustration of gangsterism, thuggery, hoodlumism, and all of this stuff, but yet still can't address the main problem of how in the hell we got there. And when you think about it and you walk around in neighborhoods and stuff like that, you see no success, you see no prosperous anything. And if we are to believe that imagery is everything, it's hard to see success when you never even seen it outside your front door. It's hard for you to be successful when the rules and regulations in which you were taught are from an unsuccessful standpoint. And it is hard to be successful when you don't even know what the word truly means in here, and in here. Meaning when you're thinking it, when you're feeling it, and when you got to go after it, you don't know what success is. Unfortunate, or however unfortunate you may want to paint it. But I'll catch you on the next one. We Reloaded.